Hey, I wanted to talk about the stand your ground law real quick. Seems like there's a few people that are still confused. So let's just take a look. This is the actual law, and it says the use of force in defense of your person. A person is justified using force except for deadly force against another person, and to the extent that that person reasonably believes that such conduct is necessary to defend himself, etc., etc. You can read it there. Basically what it's saying is you're allowed to defend yourself without deadly force. Like if someone comes up and punches you in the nose, you can punch them back. I mean, you can't chase them down and punch them back. That would be revenge. Then a little farther down it says, however, a person is justified in the use of deadly force and does not have the duty to retreat if he or she reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself or herself. And then it goes on to say, number two, under those circumstances permitted pursuant to 013, which is the castle doctrine or the home defense. So basically, they're just saying if this applies to you, if you're outside your home, then we're going to allow the inside your home law to apply to you. It used to just be this, you didn't have that protection. And of course, the inside your home law gives you all the protections that we talk about when we say stand your ground law. We've always had these in Florida where if somebody breaks into your house, you immediately have the ability to assume that they're there to do you harm, and you're allowed to use deadly force without verifying whether they have a weapon, or you don't have to make any assumptions. Once they come into your house, you can kill them. As you can see, number one gives you that presumption right there. And all the other protections that George would have would fall under this law, even though these are protections for somebody inside their home, because of the previous law telling us that this is the law that we would look to. See right here. Some people seem to believe there is a separate law, one for just standard self-defense, and then one for stand your ground. And if you don't have to stand your ground, then you can use the standard self-defense law. Well, there is no standard self-defense law. This is the self-defense law, and it would be the one George will be filing. George will file a stand your ground hearing with the judge, and if the judge does not find enough to support George, then she would pass it on to the jury, and the jury would have a stand your ground hearing. If the jury also, with the preponderance of the evidence, decides that there's enough evidence to go forward, then they would go forward with the trial and find out whether they believe George is guilty or not. So he's going to have two chances at stand your ground hearing. And the great part about it is nothing that is said in the stand your ground hearing can be carried over into the trial. So anyone that thinks that that's going to happen, it's not legal. And here you can see this is the entire law. And if I will put the link in the description below, so you'll be able to take a look at all this on your own. It's very short, simple. Florida law is made to be easy to understand. So if you want to take a look, help yourself. Good talking to you guys. Bye.